meeting is taking place in hybrid format, pertinent to the standing orders, and everybody should understand with the Zoom application, just please put up your hand. If I am totally ignoring you, Emanuela knows what this is like, just let me know, say, Karen, I need to hear from you. And in this room, just put up your hand and we'll make sure that we take down a list. Interpretation, of course, is available, and we've all used that before. Today, we do have different people in the room, so for those people who are on Zoom, today it looks a little bit different. We have Chelsea Moore here and Julia Nickel, and we also have some legislative lawyers, clerks that are also going to be helping us with this legislation. So as you know, we have a new, today we also have a new clerk on my one side, so he's going to be getting used to how it is to work with me. So for members in the room, if you wish to speak, raise your hand, as you know. Pursuant to the order of reference on Wednesday, November 1st, the committee will commence consideration of Bill S-205, an act to amend the criminal code and to make consequential amendments to another act, interim release and domestic violence recognizance orders. When ready to start, we're going to go clause by clause. I know that there's been lots of different clause by clauses that we have done in the past in other committees. This one, a little bit different because a lot of times we don't look at the justice bill. So I'm just going to remind everybody, we're going to take it slowly because I think the most important thing is that we get this right. This is all about, at the end of the day, the victims and ensuring that we get this right. I would like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the clause-by-clause consideration of this bill. As members already know, this is an examination of all clauses in the order in which they appear in the bill. I will call each clause successfully, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in their package or in the bill for each member. Members should note that amendments must be submitted in writing to the clerk of the committee. And as Stephanie noted, because we need them in both official languages so that we can get them around, so that we have them both. The chair will move slowly to allow all members to follow the proceedings properly. That's just one line all by itself. That's pretty important. Amendments have been given a number. So as you see, everybody has their amendments, and you'll see at the top corner, for instance, you will have a G1, and that stands for Government 1, for instance. So everybody in your list of packages, on the right-hand side, you will see at the number that we're referring to that. The amendment will then open for the debate. During debate on the amendment, members are permitted to move sub-amendments. These sub-amendments must be written or submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself. And finally, the committee will have to order the chair to report the bill to the House. The report contains only the text of any adopted amendments, as well as an indication of any deleted clauses. So if everybody's got all of their information, you should have your bill. Plus, everybody should have the bill in PDF format, because you'll see the line numbers on that. Does everybody, I just want to make sure it's clear that everybody has a PDF format of the bill. Super duper, we're good to go. Okay, so let's get rolling on here. The chair calls clause 1. So clause 1, we have G1. Ask the member if she wants to move it. Ms. Sonia. Sonia, go ahead.
Yes, Madam Chair. This bill, clause 1, be amended by replacing line 4 to 7 on page 1 with the following. Paragraph 515 of the criminal code is replaced by replacing line 1 on page 2 with the following. The act is amended by adding the following. You want me to give the explanation, remove measure that would require court to ask if victim has been consulted about their safety and security needs prior to making an order for bail. That's why we are moving this.
So just bring it to the committee. What you're looking is under the criminal section 1, section 515 of the Act, you're taking out that entire section from 1 all the way down to where paragraph 3 begins.
Yes.
So taking out section 1, then the consulting intimate partner, and section 2, subsection 515.4. Any discussion on that? So it's looking at removing the first two paragraphs. Go ahead, Adrienne.
Madame la Présidente, pardon,
Madam Chair, I just wanted to be sure that I understood the amendment correctly and why. Why removing? And perhaps if you can repeat, Madam Chair, the changes. Why would we remove Justice of the Peace? I think that is one of the things that is being removed at point number 2.
So I'm just going to make a quick note. So we're looking at the part right here. Which one are you showing me this? We're just looking at that same section. So there may have been an interpretation issue there because I think the word that I heard wasn't here specifically in the bill. So what we're looking at, it is this section here. So it'd be under the criminal code. It's the sections that take you straight from the criminal code down to the beginning of paragraph 3. And Sonia, I'll pass the floor over to you back for discussion as to Adrienne's question.
Yeah, Andrew, can you explain, Madam Chair? Can she?
She was just wondering why you want that part removed.
Yeah, because this is I talked about that measures that would add electronic monitoring to list of bail condition option for all crimes. Some courts may interpret this as a shifting the onus onto prosecutor. This could cause major delays to bail hearing when prosecutor cannot contact victims, threatening public safety. Victim services a better actor to take safety into consideration. Courts must already take safety consideration of victims into account in bail decisions. And it's also disproportionately will impact Indigenous, Black, and racialized people.
So I'll pull right over to you. I'm just going to let you know, because I did ask for this to be brought up. Thank you very much. G1, just to let you know, with G1, once this is moved, G1 is adopted, it means NDP1 cannot be moved due to the line conflict. So I always do like to bring this up to everybody to inform you some of the conflicts. So if G1 is moved and followed, then NDP1 cannot be moved because it's a line conflict. So it's under the House of Commons procedure and the House of Affairs. Amendments must be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment as a given line by amended only once. So right now, as I said, we are looking at G1 only. We're not going to be talking about NDP1, but I just want you to have that in mind, that G1, if voted upon, NDP1 cannot be looked at. So as you're having that, as we're having this discussion. So I do have a question for you, Sonia. So the question specifically is, it would be taking the person who is the victim, not having to ask their, and perhaps I'm just reading it wrong, but by moving this, it's not getting the consultation with the victim, or you're saying the victim was already being consulted already? Can you share?
So victims already consulted, but why I'm saying that? Because it's also impact more on a disproportionately on the Black, racialized people. And other point, just want to, Madam Chair, Bill C-233, which elevated intimate partner violence as a crime, for which electronic monitoring should be especially considered if we consider it for all crimes. Judges do not get the nudge to treat IPV with extreme care. So this is my other point I want to add.
I had Anna, and then followed by Adrienne.
So I'm a little, sorry, thank you, Madam Chair. I'm a little confused. So we're taking out, if I read this correctly, it's going to read, the criminal code is replaced by, is that what we're changing? We're taking out act as amended by adding the following?
We're taking out all of this section right here. That entire section is removed. So that consulting intimate partner section, that is the key part that would be removed in that clause that she's referring to.
All the way down to 3.1.
That's correct. Do you have another comment before I move it on, or I'll put you, yeah, one moment. No, you're good? Okay, Adrienne followed. Okay, Adrian, followed by Anita, followed by Leslyn, followed by Mark.
Madame la Présidente, vous êtes...
Thank you, Madam Chair. So you stated that if we vote on G1, we won't be able to vote on NDP1. I would just like to say that I prefer G1 over NDP1.
Thanks very much. It's just a little bit different than a studying with the recommendation, but I really do appreciate that insight. So any further comments? I'm looking at Anita, Leslyn, Mark.
Yeah, no, thanks, Madam Chair. I think that for that section that we're removing to answer Anna's question, it's because right now the courts do have to take into consideration the safety, and it's really the victim services that does the communicating. This would make it the prosecutor who would have to communicate with the victim, and in that case, if they can't reach the victim, could lead to really long delays. So it's actually a major change, and that's why we're putting forward this amendment. Thank you.
Leslyn.
To remove that section, you would essentially be removing the entire context of the bill, which focuses specifically on ensuring the safety of intimate partners and preventing further recidivism, further acts of violence and criminal acts. So if you remove that consultation part, it then makes it generic. It makes the bill generic, and it takes it out of context.
Mark, and then Michelle.
Yeah, I just wanted to follow up on the, because right now the section taking it away from the prosecutor and putting it back on the victims' services. So that's what we're in place. So I'm also in favor of G1 versus the NDP1. And the reason, as Sonia mentioned, why that's important to put it onto the victim services versus the prosecutor, and a blanket, impact on Indigenous and Black and racialized people would happen if we don't take this out. So I'm in favor of the G1 versus the NDP, and it doesn't take away from the spirit of the bill. Thanks.
Michelle?
Just to clarify, if I think I'm understanding this correctly, we're saying that we want to remove the whole foundation of this bill is that victims feel included and know what's going on, right? Like, I think that was the whole purpose, and what the testimony we heard was that there is no control, there is no feeling of knowing where their attacker is. This way, in that very vulnerable time in between a bail hearing, which we know statistically is the most dangerous time for victims of domestic violence, this gives the victim the choice to know where their attacker is. They get to be consulted. They feel like they're part of the process. And just sort of bringing this forward right now, what I see happening in Public Safety SECU Committee with the Paul Bernardo transfer, and having, the victim's family and friends of Kristen French, Laura, who testified, the biggest piece in all of that is that they were not consulted. They were not included. And it is re-traumatizing to wake up in the morning and have this news smeared on your paper or in your local media. So without the victim consultation, without the victim having their rights here, I'm not sure what the intention is of removing that.
Okay, Leah, and then back to Leslyn.
Thank you, Chair. So my understanding is this, like currently in the criminal justice process, victims can either do one of three things. They can choose not to participate, they can send in a statement, or they can testify in person. So right now, the way it's set up, victims have a lot of choice. Some people don't want to testify. Some people don't want to see their abuser for whatever reason. This actually limits, I think, the way it's worded, the power of victims to assert themselves in the way in which they choose. That's the way I understand the Liberal amendment. I I do support the Liberal amendment over my amendment. I want to be clear on that. I'm happy to not debate my amendment because I do think that the intention
We can't.
was good.
Let's not talk about your debate.
Yeah, no, I know we can't
super.
do that yet, but I know that, but I know the intention was good, but I think it actually does the opposite of what its intent is by amending it. Thanks.
Okay, on Leslyn Michelle.
Well, if you look at clause 3.1, it specifically what it's doing is it's facilitating interaction between the prosecutor and the justice who will make a recognizance determination. And so more information is actually helpful for the process, and that's how you have an equitable outcome. So I don't see any racial disparities here whatsoever. In fact, I see that this clause would allow the prosecutor to communicate with victim services, and the victim can choose or choose not to provide that information, but it ensures that the victim's situation is taken into account when bail terms are set by the judge. And I think it's very informative, it's very useful for the judge to have that information in their deliberation process. And this also ensures that the conditions of recognizance are commensurate with the gravity of the offense, because without this information, the judge would basically just be exercising their discretion and granting bail terms based on what they see fit, not taking into account the protection of the victim, which is the gravamen of this bill. And so to take it out would be actually doing a disservice to women and to victims, because the judge would not be able to contemplate what their position is, what their needs of safety is. It clearly says that the prosecutor the judge must ask the prosecutor whether the intimate partner of the accused has been consulted. This is a duty to consult, and this is a very important duty that I think that if we're understanding the legal interpretation of this clause, the duty to consult women who are victims of intimate partner violence is essential. And to remove this is basically to negate the bill.
Michelle.
Yes, and I'm not quite as eloquent and as legal savvy as my colleague, Miss Lewis. She definitely knows the legal terminology significantly better than I do. But to Ms. Gazan's point, through you, Chair, this isn't about seeing the attacker. It's about being consulted. That is the key in this messaging here. And when you read it, and I know, I was certain after spending as much time as I have in FEWO, there's nobody on this committee that doesn't understand that value. I mean, that the justice must ask the prosecutor whether the intimate partner of the accused has been consulted about their safety and security needs. This is not putting them in front of their attacker. No. This is not asking them to do any of that. Like, I'm actually stunned right now that you guys want to remove this. This is the whole point of the bill. It's about consulting the victim. It's about putting the victim first. It has nothing to do with putting them in place with that. So I just wanted to clarify that, because to Ms. Gazan's point, I understand what she's saying wholeheartedly, where you don't want to re-traumatize, or they don't want to see that attacker, they don't want to be put in the same room, they don't want to do that. But that is not what this is saying. It is ensuring that the victim is consulted about the safety and security needs.
Last one.
I find it quite disturbing that one would invoke racial connotations to say that that this will somehow bias people based on race, that a woman is consulted about her safety, a woman that has been abused is consulted, that oftentimes men who are making determinations about how this woman will be kept safe, that they should not have any information about that woman, about what she feels she needs to be safe. In this context, to remove this is a violation of every woman who has been a victim of intimate violence. And to to not recognize the importance of a judge having an opinion of what that woman feels to be safe is to rob that woman of her agency.
Any other questions or comments? Go ahead, Anna.
Because I'm listening to Leslin, and are we not the Status of Women Committee? And are we not here to protect women? I mean, how many times have we heard from witnesses where they're accused or has been let out of jail, and by the time they get informed, it's too late, and they're re-victimized? I guess that's what I'm confused about. Sorry.
And with just taking up my membership on that, I think, to be honest, I know I'm just one of the votes, but at the end of the day, I think this is about what we studied, and we heard a lot about consultation. We heard a lot about speaking to the victims, so the victims' voices were heard, and that during the criminal trial process, during all of these things leading up to that, whether or not the people have been consulted. This is specifically what it's consulting intimate partner is the key detail to this. Consultation is the piece. So I'll be quiet for a minute. Any other speakers? Seeing none, let me get my next piece of paper. Oh, was that a kind of partial? Go ahead,
Madam
Sonia.
Chair, I think we already did this with the C-233, which I already spoke on that. That is, I think, on the first part, we talked about the bail hearing. We already, which elevated intimate partner violence as a crime for which electronic monitoring should be specially considered with C-233, which we did in the...
I just want to take a moment and I'm going to throw the ball down to Chelsea and Julia. Julia and Chelsea, I just want to ensure, because this is obviously one of the big pieces, and I want to ensure that, is it already existing in our criminal code? And if not, what happens if there is a duplication because something is already occurring here in this bill, if it's a duplicate? If I could pass that on to you and get some answers, that'd be great.
Hi, thank you for the question. So just to clarify, the motion G1 would actually remove 2 proposals from this bill. I believe that might be a source of some of the confusion. So the first proposal that would be removed is the proposal to ask the prosecutor if the victim has been consulted. The second proposal that would be removed is the proposal regarding electronic monitoring. They both fall under the first clause. So the one motion deals with both proposals at the same time. Electronic monitoring, as the committee is certainly aware, there was a specific condition added to the criminal code that at bail that judges must consider imposing a condition of electronic monitoring in cases of intimate partner violence and other cases, other serious charges at bail. So that did receive royal assent in former Bill C-233. So that's with respect to the second proposal. The first proposal with respect to the obligation to ask the prosecutor if they've consulted the victim about their safety and security is not currently in the criminal code. However, there are a few sort of related provisions that have a similar intent as this proposal that would be added by Bill C-48, which has been adopted by both houses a couple of last week. So hopefully that clarifies a little bit. I think there's been some discussion about both proposals, maybe mixing the discussion together. So I just wanted to clarify that there's 2 different ones.
And that's why we need you here, Chelsea. I'm going to take it back to Leslin, followed by Adrienne.
No, you can go to her.
You're okay? Adrienne?
Donc, si je comprends bien,
So if I understood correctly, Ms. Moore, I'll give you a moment to use your earpiece, and so it would be good to maintain the consultation, if I understood correctly, of the Justice of the Peace.
Ça dépend vraiment sur...
It depends on the considerations. I could offer different considerations if you'd like around this proposal.
on peut toujours vous entendre.
So I'll just switch to English, if that's okay. So the effect of, I think, the first proposal that would remove the consultation piece. So the effect is that the proposal would be to require the bail court to ask the prosecutor if the victim has been consulted about their safety needs. So in practice, this could translate into a kind of conversation between the prosecutor and the bail justice in the courtroom about the victim's safety concerns. So some victims might welcome having their safety concerns discussed in this way. Others might feel uncomfortable with these kind of conversations being discussed in open court in the accused's presence. Currently, the focus of the bail hearing, the current practice of bail hearings is sort of to hear the allegations before the court and look at the past violent behavior of the accused and determine whether bail would be appropriate based on a number of considerations, including public safety and the safety of the victim. The Crown does make submissions on the conditions to be imposed, and it's quite standard to seek out conditions for keeping the accused away from the victim, such as no contact, not going to a specific place or area. But there is no discussion at the bail hearing currently about the broader security needs of the victim. That tends to take place with victim services, who sort of screen what government services they need to contact in order to establish the safety of the victim. But it's not currently discussed in open court what those specific security needs are of the victim right now.
Quick question for you. So would there be an option to do it privately? So I hear you talking about those conditions and security in court. Would there be an opportunity for somebody to do that outside of court, just in an informal conversation as well, so it's not in the public realm, but somewhere where the victim would feel safe?
So the victim doesn't typically appear at a bail hearing, so they wouldn't necessarily be present. I mean, it is possible, but it's usually uncommon because a bail hearing takes place within 24 hours, and it's sort of a cooling off period to separate the parties, so the victim doesn't usually show up. I mean, if you have, if the Crown feels that there's sort of a sensitive or delicate issue with respect to the victim discussing their security needs in the court, the Crown can always ask to go into chambers with the lawyer of the accused and the judge and speak about this privately. That is an option, but it wouldn't necessarily be an option for a self-represented accused.
Thank you very much. Any further, I think that really does help us, give us some more insight, so thank you very much for that. Any further questions or comments? Anybody online? Seeing none? Okay, shall G1 carry? Shall G1 carry? So we're looking at government 1. So what that would be doing would be taking out that section.
Can we have a recorded vote?
Yeah, of course. Okay. So recorded vote on this? Yep. All right. And I'll have the clerk call it out for us, okay?
Ms. Lambropoulos.
Yes.
Monsieur Seri.
Oui.
Ms. Sidhu. Ms. Kayabaga.
Oui.
Ms. Vandenbelt.
Yes.
Ms. Ferreri.
No.
Ms. Roberts.
No.
Dr. Lewis.
No.
Madame Larouche.
No.
Ms. Gizan.
Yes.
So it's defeated, or it's approved. Okay, so so that is carried. NDP 1 is out. Okay, so let's move on to G2. Everybody's got G2. Mr. Saray, you would like to, it doesn't matter, he's not the mover, correct? He can still talk about it. Will we give the floor to Mr. Saray? Oh, golly gee, Mark, you can talk. Go
Merci,
for it.
Madame la Présidente.
Thank you, Madam Chair. Can you please repeat, Madam Chair?
We're doing G2. So G2 is the next amendment. Go ahead, Mark.
Merci, Madame la Présidente.
Thank you, Madam Chair. G2 should be pretty simple. And so I'm looking at G2. that the bill S205 in clause 1 be amended by replacing in the French version line 23 on page 1 with the following. Tenaire intime s'il a été auparavant condamné. And so it's just changing the word condamné in the French. Before it was déclaré coupable in the French. So it's a technical amendment.
So a better way of saying that, okay? And I'm looking at our French speakers in the room. I'm looking at Adrienne, who's got her head going. Ariel has not said anything yet. Emanuela, do I see some nodding? You're good with that? So it looks like in the French, everyone would be okay with that. So looking at G2, shall G2 carry? All those in favor? Passes. Simple, simple. Shall clause 1 carry as amended? Okay, I'm just looking. Shall clause 1 carry as amended? Just looking at those. I'm looking online. Yeah, it passes. Okay. Clause 1, the entire. We just went through all of clause 1 is now carried. So we did amendment 1 and 2 of the government, and that was part of clause 2. So when we get on to the next clause, or that was clause 1, sorry, thanks for showing clause 1, but G1 and 2 were part of clause 1. Okay. So let me get to the next clause. Everybody moving on to clause 2. Okay, and I'll get that up on here. So G3, would anyone like to present G3? Go ahead, Sonia.
Yes, Madam Chair. That bill as defined clause to be amended by subsection A, replacing line 9 to 12 on page 2 with the following. 810.03, any person who fears on reasonable grounds that another person will commit an offense that will cause personal injury to the intimate partner or a child of the other person or to a child of the other person's intimate partner may lay an information. Section B, replacing line 32 to 34 on page 2 with the following. Section 5, the provincial court judge may commit the Section C, replacing line 1 on page 3 with the following. Section 6, the provincial court judge may add any reasonable. Section D, replacing line 4 and 5 on page 3 with the following. Or to secure the safety and security of the intimate partner or a child of the defendant or a child of the defendant's intimate partner, including condition Section E, replacing line 20 on page 3 with the following.
If you would like to, we don't have to read it all into the record.
Yes.
What we could do is I'm looking at what we have here, and I think we've got a lot of little bits that we might want to take one chunk at a time. So we could maybe start off with the A and then go through B and go through C, if that's okay with you. Because
I think that's better.
That's better?
Yeah.
Okay. All right. So let's start by looking at, it's G3, but let's look at Part A, which is replacing lines 9 through 12 on page 2. So it's 810.03, and Leslyn, you have your hand up.
Yes. So this amendment changes, firstly, it changes the entire meaning of the bill because now it's focused on any person rather than the intimate partner. The original clause read a person who fears. Now, in law, fear is a subjective test. It is a subjective test that's based upon a person's feelings. Now, when you apply it to any person, that objectifies it. It changes the entire meaning. So you cannot say that that any person and still be specific to that intimate partner. So we are actually changing the entire and nullifying this entire clause by doing that. And furthermore, when you go down further, where it speaks to will cause personal injury to the intimate partner, it changes the word their intimate partner to the intimate partner. It could be the intimate partner of any individual, right? This bill is dealing with a specific people who are facing violence. And by doing this, you're completely watering down the intent of protecting women who are in situations of violence.
Any more comments? Go ahead, Sonia.
Madam Chair, I just, I can, Dr. Lewis, yes, your point is it, but this would allow a peace officer or family friend or loved one who reasonably believes that the accused will commit an offense that will cause injury to the victim or to either of their children to apply for the IPV specific peace bond on behalf of the victim. We know that the victims of IPV often don't report the abuse for many reasons, including fear of their abuser. So this removes some elements of the proposed peace bonds, such as those relating to timeliness and allowing submissions from the informant regarding conditions to be imposed on the defendant to bring the procedure in line with the other peace bond provisions in the criminal code.
Before I bring it back over to Leslyn, I'm going to throw the floor back over to Chelsea and Julia for a comment.
Thank you. So with this amendment, the intimate partner would still be able to come before the court and seek the peace bond. What it would do, though, is it would allow others, as was said previously, to do so as well in situations, for example, where that the intimate partner may be too scared to come forward. It's very common to do it through the police and so forth. And so this would kind of also align with the way that the wording in other peace bonds, so it would not limit what an intimate partner could do themselves. It would just give a bit more flexibility potentially, but I understand the balance that you'll have to make in terms of if you want that specific language, but that would limit what is possible under this provision.
So you're explaining that right now, the way it's written in the original text, it only allows the victim to make this request, and that this amendment then would allow anyone to make this request? Is that what you're saying?
Sorry, I'm just going to add something. So peace bonds can go either two ways. A victim could bring the peace bond herself. That means she could actually fill out the form, the information, and bring it to court and sort of bear that burden. Otherwise, the victim can go to the police and say, this is what's happening. Can you help me with laying in information to get a peace bond going? As the language is currently drafted, it would only be the victim that would be able to bring the peace bond. She would be the only one that could be able to actually lay the information. The current peace bond provisions in the code sort of foresee that typically it's a police officer that lays the information. So the changes to the terminology would just allow more flexibility, like my colleague just said, to allow a police officer to bring the information.
Over to Leslyn.
Thank you for that clarification. But the problem that I have is one of statutory construction. If you have this clause constructed for a person who fears, the reason why you're using a less permissive test of fear, which is subjective, which does not have an actus reus or a mens rea component in it. It is basically based on that subjective fear. Because you're dealing with the victim. But here you've taken that very, very permissive language and then you've applied it to anybody. And so anybody who has a fear, and usually when you're speaking about people who are not direct victims of something, you don't have such permissive language. You would usually say anybody with reasonable and probable grounds, because there's a test that would be applied. And that's my only concern there, is that we're taking it completely outside of the context of this very specific
Sorry
context.
for interrupting all of you beautiful people. Bells are ringing.
Again.
Okay, so if I could just get everybody to indicate that we can continue for the next 15 minutes at least, and then we'll reassess. So we'll continue for 15 minutes, reassess, and go from there. Go ahead.
As I was saying, when we have such a specific piece of legislation that's going to be dealing with protecting primarily women, we have more permissive language. But then when we're applying it, we also have to look at that application on the broader context of the public. And so any person who fears, this is not something that I could see this, there's a void for vagueness in this language when you have it just applied to the general public. It should, you know what, I'm going to propose a sub-amendment to this then. Because
Please go for it. Now, I just want to double check in the sub-amendment. So what do we need to do? Has to be in writing. Okay, so once she puts it, can we get it in writing after that? What's the best procedure to do this? Because I understand what she needs to do here. Okay, so what we'll do is we will have you move your sub-amendment so that we can get it in writing, and then we'll suspend so that it can be distributed. Okay? So please, you've got the floor. Go ahead for it.
Any person who believes on reasonable and probable grounds that another person will commit an offense that will cause personal injury to the intimate partner, et cetera, or a child of the other person, or to a child of the other person's intimate partner, may lay an information.
Say it one more time, please.
Any person who believes on reasonable and probable grounds that another person will commit an offense that will cause personal injury to the intimate partner or a child of the other person or to a child of the other person's intimate partner may lay an information.
Okay.
I have a question, Chair.
One moment. We're just one moment. Got that? Got it all? I'm going to okay, I'll be right with you, Leah. I'm going to have the clerk repeat it, and then we'll go.
Thank you, Madam Chair. Just to ensure that we have this correctly, we're looking at G3A, replacing lines 9 to 12 on page 2 with the following. And it's that first portion where we have 810.031. And Dr. Lewis's amendment is 810.03 bracket 1 bracket. Any person who believes, instead of fears, on reasonable and probable grounds, and then it proceeds as provided. Was there another?
There was a few different words in there because you had talked about the others.
No, I've just kept their amendment and then just added the belief on reasonable probable grounds.
Okay, fantastic. Okay, so she has to get this written and distributed, but I know that Leah had a comment to make. Go ahead, Leah.
So I don't know that if this is helpful. I certainly hope it's helpful, but I do know that in when there's a suspicion of child abuse, the way it currently stands, you have a legal obligation to report. So I don't think we're really swaying too much from existing laws. However, we're now talking about, violence, which people report all the time, in fact, and then it's up to the victim to decide what they want to do with it. I don't know if that's helpful. Maybe it is totally not helpful, but I know you have to do that in law anyway right now.
Thanks so much, Leah. What we'll do is we're going to get the. Oh, go ahead, Sonia, and then we'll get this written. Go ahead, Sonia. It's on the sub-amendment.
Yeah, Madam Chair, can we suspend a little bit?
Yeah. That's what I was trying to do. We're going to suspend. Everyone will get this in writing, and what's that? Yeah, we'll just suspend. There we go.
Is it a sub?
have votes very shortly. We do have this clause 2, with the amendment that will be coming back with translation. So we are going to have to stand clause 2 and go on to clause 3, on to our next amendment. So we won't do with anything to do with that amendment because we need that in writing. So we can just go on to 3, correct? Or shall I'm just UC.
To stand the clause, and then we'll switch
Go on to that.
clause 3.
So if I could get everybody, what I need is UC motion. I just need everybody's consent so that we can stand clause 2 until we have translation available to us and go on to clause 3. All those in favor? Throw up your hands. Thank you very much. Awesome. Great. That was awesome. Well done. Emanuela, you have your hand up. You have a comment?
It's for clause 2. So when we get back to that, I'll ask the questions, I guess.
Okay, let's look at the time. Where am I at for time? Okay, it is exactly 15 minutes out from the vote now. Would we like to vote in the room and continue proceeding another 10 minutes and work and then take 5 minutes to vote? Everybody good? Okay. I'm looking at everybody. I see everybody's looking good. Happy, joyful. Let's move on, guys. We are now going to move on to
So clause 3 is a consequential.
a consequential.
So we're going to have to move on to clause 4.
We're going to be moving on to clause 4. There's a whole bunch of things that are procedural in here. So clause 3 is all dependent on something else. So we're going to go into clause 4 now. And so clause 4, let's get this on here.
There are no amendments.
And there are no amendments in clause 4. So does clause 4 carry? So no, take your time. It's all good. Not a problem. So I'll just go over again. We will not be doing clause 3 because it is linked into another clause, and clause 2 is on stand right now. So we won't be able to do clause 3 right now because of clause 2. So we'll move on to clause 4. Clause 4 has no amendments in there right now. So it's really up to us on how we wanted to proceed, whether we support it and move forward. So we can take a vote on that. So is there, shall clause 3 carry?
No, clause 4.
Clause 4, don't clause, yeah. Good thing I have her. Shall clause 4 carry? Although, yes, everybody, we got yeses on that. Clause 5 is in the exact same situation. We have no amendments, so I'm just looking for clause 5. Well, shall clause 5 carry? Yes. We're happy. We're doing really well now. So we're going to move now on to clause 6. And G9 was dealt with.
We have consequential amendments to clause 6.
Okay. Clause 6, G9, well, we're on government 9 is the amendment.
This one is a consequential.
And it's a we cannot do clause 6 because clause 6 is relevant to clause 3 and clause 3 is relevant to clause 2. So we will have to hold on. G10 is good. We're good to go there. G10, there are no amendments made to G. Ask if the under. Oh, G10, government 10. So which one are we? Okay.
You're on G10 in
G10, page 14. So Sonia, this is one that you brought forward. We're looking at page 14 of these ones.
G9?
Your G10.
G10.
G10. G9 can't be done. It's the amendments on 14, and in the body of the report, it's page 7. Not the report, but the legislation. Okay, so G10. Yes. So G10, so it's under subsection 3. Go ahead, Sonia.
Yes, Madam Chair. Removing the requirement in relation to the timeline, so making an order to relation ability for the informant to make submission as to what condition should be imposed on the defendant. subsection 8 and adding the word intimate partner and attorney general in subsection 12 to ensure both the intimate partner and the attorney general can apply to vary the condition of the recognizee in addition to the defendant.
Okay. Anita's got her hand up. Go ahead, Anita. Because I hear people.
Yes,
don't
my understanding is that G10 is consequential of G3, so I don't know that we can necessarily do that now.
G9 is consequential, but not G.
Could we suspend for a moment because I'm very confused? Thank you.
Let's suspend. We'll suspend. as we've gone through this, we're going to let you know that there are a few different consequential things. So what we have is there is clause 6, which has G9. We introduced G10, but there is a consequential issue here as well. So this is a consequential change. So what I need is unanimous consent. So because I had already presented it, we need unanimous consent so that we can stand clause 6 as well. Everybody sound good? Thank you very much. Now we're on to clause, so she's keeping me going, you're awesome. Clause 9, okay? So everybody to clause 9, and that is page 7 of the, sorry.
There are no amendments.
There's no amendments to clause 9, sorry. So clause 9 as carried, good? Carries, okay? Let's look at clause 10. Once again, there's no amendments on clause 10. Shall it carry?
Madam Chair, it says clause 10.1. What's the difference?
That's clause 10, new clause. That's a new clause. So there's clause and there's a new clause. So that's 10.1 that you're referring to. So shall clause 10 carry? Great. Now we go on to the new clause of 10.1, which is G14. And if you want to present G14, Mark or Sonia, go for it. G14, we're at the very end at 10 point. Yeah, this one flew because so many things are consequentials. So we're now at the last one, the G14. And this is a new amendment that's being made in here, so 10.1.
Madam Chair, this is a technical. It's also consequential. Yeah. It's a code technical.
G14?
G14.
I'm going to open the floor, allow Sonia to put it forward, and then Leslyn, and then we can carry on. Go ahead, Sonia.
Yeah, this is a technical coordinating amendment to ensure that Bill S-205 is in line with another bill the Parliament is studying, C-21, should both bills be passed.
So it is a coordinating amendment, but it is not consequential to any other amendments. So that's what that is on. Okay, go ahead, Leslyn, go for it.
I actually see this very differently because if you look at G3 clause, Article 2, if you look at under I don't even know how to read this. Okay, I would say bracket 8 on page 2 of the committee stage document. You will see that there's a reference that Clause 8 completely changes Section 7, which references the firearms section. It changes it to Section 9, which that doesn't make any sense, actually. But it changes it to Section 9, which is not the firearms section. And if you go down to Clause 11 further down, you'll see that it does it again when it speaks about the defendant makes an application under Section 10. It's changing, it's amending that. And so it's amending the firearms section, and this G14 specifically deals with the firearms section. So technically, the firearms section in these two provisions should be dealt with before you contemplate anything to deal with G14, because G14 contemplates that Bill C-21 must be introduced prior, and it may be moot if you deal with the firearms section. So you can't deal with this without dealing with those two amendments first.
I'm just going to throw, I'll come back to you, Mark. I'm going to throw this over to the official. So if you could give your insight, your 2 cents on this. Thanks.
Thank you. This motion, G14, would make some changes to ensure that some of the changes in previous clauses line up with Bill C-21, and the previous clauses include Clause 2. So there's a condition under the new, that would be proposed under the new peace bond provision. Currently, it's subsection 9. No, sorry, yes. Currently, it's subsection 9 on page 4 of the bill. That's a list of conditions that the defendant would have to comply with or potentially comply with if they're on a peace bond. So in that list, the word firearm part is missing. Firearm part would be added by C-21. So I don't believe that I don't know exactly all the rules, but I don't believe it can be debated since it deals with that clause, and we haven't changed the numbering in that clause yet. And this provision proposes new numbering to reflect motion that would have passed. So
you're saying it's consequential on another clause?
Yes, clause
Okay.
2.
Clause 2, okay. I will allow two more comments, but just to finish the ruling on that, I think I got it. We're going to go to Marky Mark and then back over to Leslin. I don't know why.
Yeah, just quickly, Madam Chair, I just wanted, I think this is very, it's simply technical, and I don't know about the aspect of Clause 2, but essentially, when we're looking at the ensuring the two bills of language, I don't think this amendment, G14, takes away from S205. It just aligns, if I understand correctly, aligns the two bill, and it doesn't take away or add. So I thought this was a simple amendment, but.
Yeah, and that being, it is simple. It's just the only thing is, as they indicated, there is some consequentials because of Clause 2 in there. Leslin, you've got the floor.
Yeah, I thank Chelsea for her clarification, but I think it's imperative that from a statutory construction perspective that we deal with Clause 2, because if you look at Provision 8, it actually changes from the entire meaning. It changes it from looking at the recognizance section to changing it to the firearms section. So there's two different things that's spoken about. And if that section actually changes, then it's going to have an impact on G14 also. So that's why I think it's imperative that we have to deal with Clause 2 before we can actually make this amendment. It's connected.
So you're absolutely right, Leslin. As we've indicated, Clause 2 cannot be done, though, because we're waiting for a translation. So once we have that, we can do so. Instead, what we'll be doing is we will not be able to continue with today's bill. We'll have to look at everything else. Everything will have to be put on stand because we'll need to wait for the official translation so that we can do Clause 2. And then from Clause 2, everything else will be able to roll. Are there any questions? Because we're about to leave then, right? Everybody's good? Okay, so today's meeting.
Just one little question.
Go for Emanuela. Emanuela, you do see that I've got the hammer in my hand, right? Okay, go for it.
You weren't recognizing me, and I was on there for a long time.
Then you tell me. Go for it.
Mm-hmm. So, are we seriously gonna stop this committee because of 3 words that need to be translated?
Your boom mic needs to be put in.
3 words.
Your boom. It needs need to hear you a little bit better. So if you could put your boom mic in a little bit closer to your mouth. Awesomeness. Thank you.
Okay. So is it just the 3 words that need to be translated? Believes and probable?
Although that is the case, it needs to be legally translated. It cannot just be done by brilliant people like yourself. It has to be done at an official translation for legality reasons. So it has to go through that. So I know we have some amazing people in here. We could translate that, but there are certain words that are very, very important, especially in the court of law. So seeing no other questions or comments, I will just remind everybody on Thursday, we have main estimates with Minister Ian. We'll be rescheduling a portion for this meeting so that we can get back to S205, and we'll get a new schedule out to you because we need to get back to this as well. But today's meeting, seeing no other questions or comments, today's meeting is over, closed. Bye.